Michigan Justice Chronicles with Dan Geherin takes you inside the courtroom and behind the scenes of criminal defense law, uncovering the strategies, stories, and stakes that define justice in Michigan.
Welcome to Michigan Justice Chronicles with Dan Geherin. I'm Sam Henniger, and I'm really excited to meet today with Dan to get to know him and his journey as a criminal trial attorney. So Dan, welcome. I'm really excited to chat with you today.
I'm excited to be here, Sam. Thanks for having me.
Let's get started with understanding a bit more of your background. What initially drew you to the criminal justice field?
Sam, I get that a lot. People always ask me, how did you end up where you did? And I sort of start at my beginnings. I practice here in Washtenaw County, Ann Arbor, Michigan, and I was born and raised in this town. One of the things I proudly say is born here, raised here, practice here. And my father was a professor at Eastern Michigan University, and he's also a true crime writer. So I was a teenager, and my dad handed me a book called The Michigan Murders. And The Michigan Murders is a book about a serial killer here in town in the late 60s and 70s that killed a number of young women. And it's a great book on the investigation into finding the killer. And not only that, but the prosecution and the defense of the killer in the courtroom. And I remember very vividly finishing that book and thinking to myself and maybe telling my father, I'd like to be a detective, a prosecutor, or a defense attorney. And 40 years later, I've been a prosecutor, I've been a defense attorney, I've not been a detective. And so I went to college with the idea of becoming a prosecutor or a defense attorney. I became a prosecutor out of law school and then eventually became a defense attorney. And as I said, many, many years later, I'm still in the exact criminal justice field.
That's very interesting. And I know that you've been practicing for the past 27 years. What significant changes have you seen in the criminal justice landscape?
Well, there's been a ton, and I've seen it from both sides of the field, right? So as a prosecutor, I was fortunate enough to have all of the resources that prosecutors do, the training, the law enforcement at my disposal, the resources that a government agency has. And I started in Los Angeles, which is, in my understanding, the biggest prosecutor's office in the country. So I saw the power of government, the power of the prosecuting attorney's office. And then in the last 25 years, I've been on the other side of it, many times sort of the lone wolf in a David and Goliath situation. So I've seen from that perspective how someone's rights can sometimes be trampled, how the resources are not always even from both sides. And then, of course, Sam, I've seen a lot of changes in the laws, in the procedures, in the way that jurors and judges view justice. And there's just been a significant amount of changes. And I'm guessing if I practice another 25 years, I'll see significant changes over those decades as well.
Could you point to some specific or formative experiences, moments in your career that really speak to your passion for this type of work?
I started in the Los Angeles County District Attorney's Office in 1997. And if you think back, that was right on the heels of the O.J. Simpson trial. In fact, I was interviewed by a member of the O.J. Simpson trial team. I was hired by Gil Garcetti, who was the prosecutor at that time. And so that was a big case, obviously, one of the biggest in United States justice history. And I had a familiar interest with that case. I knew a lot of the people involved with it. And then my direct supervisor was a prosecutor on the Charles Manson trial. And he sort of trained me on how to be not only a trial attorney, but a prosecutor and a criminal trial attorney. And so you talk about the two most famous cases in justice history, O.J. Simpson, Charles Manson. I had sort of a periphery connection to both of those cases. And that really sort of lit the match for me in the justice system. And then from there, I came back to Michigan. I became a defense attorney. And I've really sort of been in many different pods, Sam, of the justice system. I've been an appointed attorney representing indigent defendants in cases ranging from misdemeanors to murder cases. I've been a part of a small firm where we only practice criminal defense, one of its only of its kind in the state of Michigan. And since 2018, I've operated a firm that really umbrellaed out into do criminal justice. And I'll be happy to explain that in more detail, but seen a lot of changes over the years, seen virtually every aspect of the criminal justice system. But I think it was that beginning in the prosecutor's office, the training I received, as I said before, that sort of lit the match that still burns for me almost 30 years later.
And since you mentioned how you have such a breadth of experience and even some high profile experience, some connections there early on, as you're working now, what are some of the specialties or types of cases that you work with that you're most passionate about?
So our firm really handles anything with a criminal justice element. That does take a little bit of explaining my elevator speech, as they say. So not only do we defend people who are charged with crimes, and that's always been a big component of my practice, but we also handle cases where there's a criminal justice element. For example, we handle Title IX actions at the university level. If a student or a professor is facing expulsion or facing being terminated because of something they did on campus, we handle those cases. We also will handle lawsuits. If someone is injured or killed or wronged due to the criminal actions of another, we may take that case. For example, we may sue a bar who overserves someone and that person harms others. We may sue a police department if there's brutality. We may sue a school system if someone's rights are trampled on. As long as there's a connection to criminal justice, we will consider taking the case. We also do a lot of administrative law that has that criminal tinge to it. Driver's license appeals, administrative hearings, a lot of juvenile justice. And so if there's a criminal justice element to it, if we think we can help, that is something that we're interested in doing. And as long as we have a passion and think we can help the particular client, that's a case that we're always interested in looking into.
And for the layperson, I know for me in particular, it can be sort of obtuse, not easy to understand the differences between criminal and civil cases. Could you give us a little explanation on where those lines might cross? Because criminal, I'm sure, violence, fraud, some big bad things happen there, but there may be some nuances that people aren't aware of.
Yeah, you're absolutely right about that. Even people I'm close to, that I've known for 25 years, say, what is it you do again, right? So I don't think that people outside of the justice system really have a good fit or handle on exactly what it is that each side does. But so there's the criminal system. If someone is accused of committing a crime, ranging from a misdemeanor, a drunk driving, all the way up to some of those more serious crimes you mentioned, Sam, then a branch of government is going to prosecute them. So it might be the state of Michigan versus John Doe. It might be the city of Ann Arbor versus Jane Doe. And then you have the higher level offenses, federal offenses. So it could be the United States of America versus John Doe. And so that is a criminal case. That is a unit of government saying, you've committed a crime, sir or ma'am, and we can prove it. Whereas a civil case, it's about a remedy that usually involves financial remedies and sometimes other types of changes in the law or changes in procedure. So a civil case is typically John Doe versus a bar, an insurance company, a school system, a police department. And the primary goal in a civil case typically is to be compensated for a loss or to be paid back for some sort of loss that occurred, or, as I said, to change procedures or to change an unfair result, a civil justice type case. So there is a difference. We do a little bit of both, although primarily the civil cases we do, as I mentioned before, have some connection back to a criminal element to it.
I think one thing people don't realize is just how nuanced the law system can be. And when you're trying to navigate it, it's very helpful to have somebody who knows these types of things. And as you mentioned, can distinguish between criminal and civil law and how these things operate. Could you explain to us the differences between when an adult is involved in a criminal case or when a juvenile is involved?
Yeah, it's an interesting question because we talked already about the main difference between civil and criminal in those two buckets, right? And then within each, you might represent an adult and you might represent a juvenile. Now, in Michigan, a juvenile is defined as a person under the age of 18 for the most part. And we can talk about exceptions, but juveniles are charged with what are called delinquency offenses. So if a juvenile commits a serious offense, while it is a crime and it has all the markers of a crime, it's called a delinquency offense in Michigan. Whereas for an adult, it's called a crime. Now, when you represent a juvenile, there are certain ethical considerations that come into play. For example, you're representing them. You're not representing their parents, despite what parents may think, even if the parents have paid. So that presents its own sort of unique environment there. Also, if juveniles are trying to bring a lawsuit, for example, typically there needs to be a next of kin or some adult named in the lawsuit as well. It is rare that juveniles bring civil cases. And in fact, I don't think I remember having one. So the majority of civil cases are brought by and against adults. But there is a lot of criminal delinquency action against juveniles. And here in a town that I practice in, we've got high schools galore, we've got colleges galore. And so one of the big practice areas we do specialize in is juvenile justice. But you're right, there's a difference between representing adults and juveniles, both in terms of procedures, ethics, and the outcomes of those cases.
What are some of those big distinctions? I know you mentioned how you are representing the juvenile rather than the parents, even if they're paying. That's a big point there. But what else?
Yeah, good question. The single biggest distinction, and it's that way for Michigan, and I'm going to guess for most states it was in California where I practice. The stated goal for juvenile courts is rehabilitation. In fact, there's case law, there's statutes that says we are trying to rehabilitate Johnny or Jane in this case. That is not the case for adults. For adults who are prosecuted, there's a series of goals, rehabilitation being one of them, but it's naive to think that's the main. And often the main goal in adult prosecution is punishment or deterrence or removing the person from society. With juveniles, the goal is to make sure this person doesn't do it again. And so it is a friendlier environment, for lack of a better word. It is a much easier practice area in the sense that, generally speaking, your juvenile clients are not being shipped away to prisons and jails at a rate that your adult clients might face. And really, for me, one of the differences is the rewarding factor, because for many of these kids, there is that scared straight element, and they do something stupid and the court gets the attention of them. They don't want to do it again. And so they are very receptive to our advice. They listen very well. They typically are very friendly with the courts and want to make sure that this never happens to them again. So there's some ethical considerations. There's definitely the stated purpose difference between adults and juveniles. And just on a personal level, there's an enjoyment in representing juveniles because you can sort of make a difference in a young kid's life, making sure that they never repeat that behavior.
I think anybody who's involved in social work or things working with youth, they can really relate to, again, the rehabilitation more than the punishment, just as you said. Now, you mentioned that you work with Title IX and university actions. Perhaps give us an example or lay the stage for what a case like that might entail.
So Title IX is a relatively new term in the justice system. For many, many years, I practiced here in town where there's the University of Michigan in Eastern Michigan. So we're talking almost 100,000 students. And when students would get in trouble on campus, not necessarily with criminal actions, but they would do something on campus to another student or something internal, it was called a discipline action, and the student might face discipline. And many years ago, the universities that are state funded or funded by the government said, now we're going to make sure that gender is protected. If someone on campus commits a crime that is gender-based, call it sexual harassment, sexual assault, domestic violence, partner violence, then they have violated potentially the Title IX regulations of the federal government, and they face sanctions at the university level. Now, so if a student gets notice of a Title IX violation, they are facing being expelled from school. That is the ultimate sanction that might occur for a Title IX violation. So you might have a student at school, he's 3 years into his high-priced degree, and he does something against another student, and if he's found responsible for a Title IX violation, without hesitation, the university will kick him out of school, not to return again, whether they lose their tuition dollars or not. So Title IX cases have been a very big development over the past, I'd say, decade, at least here in Michigan and probably in most states where there are major universities. We've been at the forefront of those, handling these cases. And we not only handle them for students who are facing Title IX actions, but we represent victims or what we call complainants in these cases and try to help them navigate the Title IX actions as well at the university. So big developing area of law, constantly changing development in the law because the federal government regulates Title IX. So that is a constantly moving target and a very growing practice area for those of us in the justice arena.
Perhaps you can point to a particular case that you've worked on that describes what a favorable outcome looks like when it comes to Title IX.
It's a really interesting question. You know, if someone is not responsible, and there are false claims, there are exaggerated claims, if someone's not responsible, the right result is that they are not removed from school, that there is not a finding of responsibility. If I'm on the other end of it and I'm representing a complainant who feels wronged by the action of another student or a professor, letting them see justice, seeing that that student or that professor is removed from the university can be of great consequence for them and can be of great benefit to them to know that that person is removed from their external environment. So it sort of depends on what side of the case you're on as to what the benefit is or what a good result is. These cases are long, they are complicated, they are sort of messy, but if you get the result that a client is looking for me, that is the sort of the positive reinforcement we're looking for.
That's great to hear. Now, I'm quite interested to hear more about your work with some very high-profile cases. Across your 27 years so far in law, what is perhaps another personally memorable case for you that you'd like to share?
There's been a lot of memorable cases, in the sense of cases that I get asked about the most, that are high profile or that have made their way to Dateline or to local media or things like that. There are cases I've handled that just have a local interest in it, whether it's a football player or someone connected with the university or a politician or what have you. But to me, the most memorable cases are the trials that we've won for clients that I truly, in the bottom of my heart, believe were innocent. Now, those aren't necessarily all that frequent, and I don't say that cynically, but the number of clients that have gone to trial, stated their innocence from the beginning, and I have believed, based on the evidence and everything I've seen, that they were innocent, getting that not guilty verdict or succeeding in those trials, those are the most memorable to me. And there are people that reach out to me 10, 15 years later and send cards at Christmas and things like that, just thanking us. And I guess I would say, without giving names and so forth, those are the most rewarding, because if you have a client you believe is innocent, the pressure of winning that case is immeasurable. And the joy when they do is also pretty much off the charts.
I can only imagine, but I'm thinking on the opposite spectrum, perhaps, of that. I'm curious what your experience has been navigating the ethical sides of things when you know that the person you're defending did it.
Yeah, that's a how do you sleep at night question that you get. And you get it even from people that are friends or that really sort of have a small understanding of the justice system. And I don't mind that question, because in reality, the public doesn't always know this, but we don't know necessarily when clients are guilty. I never really come out and say, are you guilty, and press people on it. I want the version of facts. I want to know the truth from their perspective and so forth. But if I know a client is guilty, or if I know a client has a certain version of events, the one thing we can't do is allow them to testify contrary to that. And that's really what the public doesn't understand. We cannot, what is called suborn perjury. So if a client says, yes, I robbed that bank, we cannot allow that client to come into court and say, I did not rob that bank. That is an ethical violation, something we take obviously very seriously. So there is not always the knowledge that someone is guilty, but even if we have a belief, our job does not change. It is still to zealously represent a client within the extent of the law. It's what the Constitution demands. It's what our oath of office demands. And those of us who practice in the criminal defense arena take it seriously. And when I'm on the other side, whether it's prosecuting offenses or civil litigation, you always remember your ethics. You always remember that your job is to fulfill your client's objectives within the reasons of the law, and to do so zealously.
I appreciate the term zealous, because I think a lot of people, they want somebody who will fight for them, to go to bat, so to speak. How do you go about selecting the cases you take? Because I'm sure there are many people who come to you, but you can't, well, just bandwidth-wise, you can't take all of them.
You're right. Bandwidth is a great word, Sam. And bandwidth, volume, fit, these are all sort of part of the equation that goes into it. If a client contacts us and they're in our criminal justice sort of purview, our umbrella, and if they are geographically fairly close to where we practice, that's a good starting point. So I'm not going to take a case 4 hours from now, because I don't know the judges. I don't know the people up there. So there's sort of the geographical fit. There's the case type of cases we handle fit. And then from there, there's just got to be a connection. I've got to make sure that they are willing to work hand in hand with us, that they are motivated, that they are interested in the process. And then beyond that, of course, there's financial considerations. We've got to make sure it makes sense for us financially, and that the client can afford services. And if they can't, we may make exceptions. We have always done discounts for veterans and for students. We take some pro bono cases, free cases every year, and discounted cases. So there's an equation that goes in, time of year, type of bandwidth, as you said, volume. But if it's in that criminal justice arena, in our geographical arena, that's certainly something that would be a good starting point for our firm.
And what about the cases that come to you that are particularly complex or high profile? Because I know, for one, the cases that you hear about, everyone pays attention to, everyone has an opinion. And that, I can only imagine, adds a lot more stress to everybody actually working on the case.
Yeah, it's true. And like a great athlete that says they block out the crowd noise or the media, if you're in a high profile case, you have no choice but to block out the noise and focus on your job and do the best you can. Yeah, there are going to be cases that are going to have certain venom. On the other side, you walk into a courtroom, you're representing the person that they believe did a wrong, hurt somebody, whatever the case is. And so you are sort of wearing that black hat at times, and you've got a prosecutor and police and a victim's family all looking at you as if you were the enemy along with your client. But also there are many cases where that's not the case. There's sort of a congeniality to this practice, especially here locally. Everyone's got a job to do. And as I said, because we practice in different areas, it's not always wearing the black hat. It is not always feeling that way. But anytime you have a high profile case, a high emotion case, a sensitive case, it does amplify the sensitivity going in. And we've got to be mindful of that. And when we decide to take a case.
It's one thing to work on a high profile case and do good work, getting a favorable outcome as you can, but it's another, I believe, to build a strong reputation for your firm and for yourself personally. What have you done to build that strong reputation in your community? Any certifications or things like that you've done to help bolster it?
Yeah, reputation's everything, right? And I think for people looking for an attorney, especially in the criminal justice field, they're going to play Google roulette and they're just going to do their best. And everyone's going to say they have X amount of experience or that they're tough or that they're experienced or whatever buzzwords you're going to say. What we try to do is point out things that make us, frankly, a little bit different. And a couple of those things, client reviews are pretty important, obviously, whether it's a restaurant or it's a doctor or it's an auto mechanic or it's a lawyer. So client reviews are important because they're authentic and they're people that have been through the experience. And we're proud to list our reviews out there and have 300 plus 5-star reviews or so. So that's one way our reputation sort of jumps off the page. Another is I was proud to become board certified as a criminal trial attorney a number of years ago, in 2017 to be exact. And that was a culmination of 18 years of trial practice to get to that point. It is not easy to become board certified. There's an organization called NBTA that screens attorneys and ultimately decides if someone has enough trial experience to be board certified. You had to have a certain number of trials, whether it was 100 trials or certain hours in trial. You had to have letters from judges and from prosecutors and opponents, and you had to take written and verbal exams to get that designation. And even 10 years later or whatever it's been, that's continued to grow. I'm proud to say I'm board certified, but that continually grows with each trial that we have. So I think it's a combination, Sam, of putting out there the client reviews, showing that you're board certified, and then also you get some peer rankings. There's something called Martindale-Hubbell that ranks, and we've thankfully gotten the highest rating, which is called AV Preeminent. So I think those 3 ways that set us apart to show that we have a reputation, that we're ethical, and that, frankly, we're good at what we do.
Dan, that says a lot about your willingness to communicate with your clients, the people you're attracting for the cases, that they need your help. So I'm very appreciative of getting to know you, Dan, your experience, your history, and I look forward to future conversations.
I do too, Sam. Thank you so much.
This has been Michigan Justice Chronicles with Dan Geherin. I'm Sam Henninger. Remember to like, subscribe, and share because we're going to have a lot more great conversations just like this. Dan, thank you again.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.